Now I'll give the floor to Professor Payam AKHAVAN, who is a barrister at 20 Essex, London, as well as the chair of human rights at Massey College, University of Toronto. In fact, I first met him. He came to my lecture at the Bonavero Institute of Human Rights at Oxford many years ago, so his interest in human rights is deep-rooted. And he has been a driving force for advisory opinion on climate change in many forums, especially ITLOS and ICJ. You have the floor.
Thank you. Thank you very much. I would like to begin by expressing sincere appreciation for the invitation to attend this distinguished gathering and for the exceptional hospitality of our Korean friends. So, Gamsabdina, and thank you very much. I would also like to pay tribute to the outstanding legacy of Korean jurists. It is quite remarkable. We have Korean jurists on the ICC, the ILC, ITLOS, and hopefully the ICJ. And it is a testament both to the exceptional talent that resides within this country and the commitment of Korea to the rule of international law. I will focus my comments today for the students in this room. I will not relitigate issues before eminent judges who've already heard me enough times. So with your permission, I will provide an overview of the problem of climate change, what the ICJ referred to as an existential problem of planetary proportions that imperils human life and the very health of the planet. And then to explore why it was that the small island states initiated these historic proceedings before ITLOS, and perhaps to reflect on the potential and limitations of contentious proceedings building on the jurisprudence that has been generated thus far. So I will begin with the story of Tuvalu, which became independent in 1978, became a member of the United Nations in the year 2000. It is a microstate, population 12,000 indigenous Polynesians whose communal identity is inextricably tied to their ancestral territories, but also an atoll with an average elevation under 2 meters above sea level, and one of the states that is likely to disappear in the very near future because of rising sea levels. Here is an illustration of Tuvalu at high tide currently, and with a temperature rise of 2 degrees Celsius, which would result in a 34 centimeter increase in combination with strong storm surges, which leads, among others, the UN Development Program to note that by the year 2050, the main island will be submerged by half at high tide, and by the year 2100, 95% of Tuvalu will be submerged. So it is no exaggeration from the perspective of Tuvalu, which happens to be my client, to say that the question of climate change, or rather the failure of the major emitters to do what is necessary, is an existential threat. And perhaps this image, which some of you may be familiar with, makes the point. This is Simon Kofi, the then foreign minister of Tuvalu, at COP26, which was held in Glasgow during the pandemic, who appeared via Zoom and made his speech in an area that was once upon a time a dry land, to make the point. So moving on quickly to the so-called climate change regime, which of course is based on the UN Framework Convention on Climate Change, adopted in 1992, 10 years after UNCLOS was adopted, and of course in 1982 climate change was not yet a thing, if one can say. It was really in 1988 when Dr. James Hansen for the first time introduced the term global warming into our lexicon at his testimony before the US Senate, and 4 years later, the UN Framework Convention was adopted as a global regulatory regime to address this issue. And by 2015, the Paris Agreement was adopted under the Framework Convention, and one of the objectives of the agreement was holding the increase in global average temperature to well below 2 degrees Celsius above industrial levels, and pursuing efforts to limit the temperature increase to 1.5 degrees above pre-industrial temperatures. And this, of course, is not an ideological proposition, it is a science-based conclusion. And today, it is understood that even the 2-degree target is perhaps too high, and it is necessary to limit global warming to 1.5 degrees Celsius by the end of this century, although last year that threshold was already breached for a sustained period of time. And that is because the UN Intergovernmental Panel on Climate Change indicates that crossing that threshold would unleash far more severe climate change impacts, including more frequent and severe droughts, heat waves, and rainfall. And of course, to limit global warming to 1.5 degrees Celsius, it will be necessary to peak in greenhouse gas emissions this year in 2025 and to achieve a 43% cut by 2030. So the main procedure or instrument by which greenhouse gas emissions are to be mitigated under the Paris Agreement are so-called nationally determined contributions, which are to be communicated regularly and which are to be progressively ambitious. And on one view, this is a procedural obligation, not a substantive obligation. I will return to this point shortly. The problem, however, is that the NDCs, and we now have, as we are holding this panel at this very moment, it coincides with COP30 in Belém in Brazil, so more than 30 years after this global regulatory regime has been achieved, where do we stand? If all the NDCs, current NDCs, were complied with, which they are not, we would be at the year 2100 at 2.3 or 2.5 degrees Celsius above pre-industrial temperatures. But based on the current policies, we are set to achieve 2.8 degrees Celsius, which is catastrophic, and this is not an exaggeration. So it was the failure of the COP process that allowed small island states to conclude that they should turn to international courts and tribunals, because much of what they were seeking to achieve unsuccessfully in the negotiations was already part of binding international law. So here at COP26 in Glasgow, the prime ministers of Antigua and Barbuda and the Caribbean and Tuvalu concluded the agreement establishing COSIS, which was opened for accession by other small island states, and 9 members eventually became members. The agreement was deposited with the UN Secretary General, and here are the 9 members, 5 of which are from the Caribbean, 4 of which are from the Pacific. One of the provisions of the agreements allowed the Commission, consistent with Article 21 of the ITLOS statute and Article 138 of its rules of procedure, to request an advisory opinion. On the 12th of December 2022, before the General Assembly adopted the resolution requesting an advisory opinion from the ICJ, a request was made by COSIS to ITLOS, and by September 11th, 2023, a hearing was held, and throughout the process, some 40 states, parties, and international organizations participated, whether in written or oral pleadings. One of the notable moments in the hearing was my colleague Naima Temaile Fifita, getting back to the theme of the students in this room, youth, future generations that will have to deal with the catastrophic effects of climate change. She spoke elegantly with her crown of seashells about the fact that the island after which her grandfather had named her had already become submerged, and that she had to think about a world in which her country would not exist. May 21st, 2024, the tribunal rendered a unanimous opinion, not an easy feat, given that there are 21 judges on ITLOS. And what I will do now in the time that remains is go very briefly through some of the central aspects of that opinion. So firstly, the tribunal had to conclude that greenhouse gas emissions constitute pollution. And once that predicate question was answered, the obligations to protect the marine environment under Part 12 were triggered. And the basic obligation is contained in Article 192. The students in the room can consult these provisions. I will race through them very quickly because of the limited time that we have. But the basic obligation to protect and preserve the marine environment guides the entirety of Part 12. And there is more specifically Article 194, which requires states to take all necessary measures to prevent, reduce, and control pollution. So the power of the case that COSIS put to the tribunal was its simplicity. Once you conclude that GHG emissions are pollution, then you simply go through the provisions of Part 12, and those spell out the obligations of states. One of the important points, of course, was that in arriving at the conclusion, replicated as well in the ICJ opinion, that the due diligence obligations are particularly stringent, the tribunal looked at this not as a legal abstraction, but in light of the best scientific evidence, which brings us back to the 1.5 degrees Celsius threshold. A purely abstract formulation of the due diligence obligations perhaps would have been less useful, given the fact that at least one of the objectives of the small island states was for this jurisprudence to shape the COP negotiations, so there's clarity as to what is discretionary and what is not. One of the central issues, of course, and this turns to the previous presentation as well on systemic integration, was the relation between UNCLOS and the UN climate change regime. A number of states, invariably the major emitters, were of the view that the climate regime contained purely procedural obligations, and that those procedural obligations somehow qualified as a sort of lex specialis without the lex. And the tribunal rejected that proposition on the grounds, inter alia, that the Paris Agreement does not require the parties to reduce GHG emissions to any specific level according to a mandatory pipeline, but leaves each party to determine its own national contributions in this regard. So there was no normative conflict, there was no question in respect of lex specialis. Here there is a notable divergence because the ICJ, to the contrary, adopted the view that the NDCs were not purely discretionary and that they were in fact both procedural and substantive obligations which tied states to 1.5 degrees Celsius. So the ICJ perhaps threw caution to the wind and went further than ITLOS in this regard. But of course, both arrived at the conclusion that whether we look at the Paris Agreement as containing purely procedural or substantive obligations, there was no question of lex specialis, no question of a specialized regime that would displace the general obligations under international customary law or UNCLOS, as the case may be. The ICJ addressed state responsibility directly because it was part of the question put to it, unlike the question that was put before ITLOS. And it is remarkable in this specific paragraph 427 that it refers to fossil fuel production, consumption, and subsidization as qualifying potentially as an internationally wrongful act, perhaps one of the most remarkable aspects of the ICJ opinion, which of course also shapes the ITLOS opinion. Moving on to the question of dispute settlement and the prospect of contentious proceedings. The ICJ statute, as students will be well aware, has an opt-in procedure. States may be party to the ICJ statute without recognizing the jurisdiction of the court in specific instances, so there must be either a compromissory clause in a treaty, a special agreement, or a declaration under Article 36(2). In contrast, the Part 15 procedures, especially Section 2, referring to compulsory procedures entailing binding decisions, assumes as a default dispute settlement procedure arbitration under Annex 7, unless the parties have agreed to refer a dispute to ITLOS or the ICJ through corresponding declarations. If we had time, we could discuss the perhaps wisdom of this provision, given the fact that it leaves parties very often in a position where they do not benefit from the advantages of going before ITLOS, whether in terms of cost or efficiency. That's a discussion for another time. But what is significant for present purposes, and I don't expect you to read all of that just now, but you will notice in Article 298 optional exceptions that whereas states may opt out of the Part 15 procedures in respect, for example, of maritime boundary disputes, there is no possibility to opt out of disputes in relation to protection of the marine environment under Part 12. So in effect, there is compulsory jurisdiction under UNCLOS for disputes relating to Part 12. And this opens the possibility, notwithstanding the very complex issues of causation, attribution, the application of the law of state responsibility on matters such as the duty of cessation, non-repetition, restitution, compensation. There are a whole gamut of very complex issues which have been left understandably unaddressed by both ITLOS and the ICJ, which would be raised in proceedings before Annex 7 arbitral tribunals, ITLOS, the ICJ, should there be contentious proceedings. Now, I will end by perhaps reflecting more widely on the degree to which international courts and tribunals are the appropriate means of addressing the failure of the international community, the major emitters in particular, to do what is necessary to prevent catastrophic harm. And it brings me back to the beginning of my presentation. The reason why the small island states, the smallest of nations, have led this process is because they will virtually disappear in the foreseeable future. So in my closing remarks before the tribunal, I addressed the question of the legacy of this proceeding in the years to come among future generations, including the students in this room, and put forward the proposition that either a unified humankind does what is necessary now to address climate change, or it will be forced to do so after unimaginable catastrophes leave no other choice. And this leaves me perhaps with a final reflection, looking at this beautiful view of Tuvalu that I had the privilege of seeing last year, and thinking that this image may soon be really a memory from a distant past, to really reflect on both the limits and potential of international law, perhaps in inducing greater compliance with the obligations of states, because at the end of the day, we're not going to solve this problem merely through litigation, but perhaps international courts and tribunals can play an important role in deterring the continuation of this unlawful conduct before it's too late. So thank you very much, and I will stop there.
Thank you very much, Payam.